Hello, everyone. A warm welcome to each one of you. I'm Priyanka Singh, the Marketing Director at PMO India Hub. I'm delighted to be here hosting a highly anticipated episode of the PMO Insight Series. This series is proudly brought to you by PMO India Hub, the esteemed local community of PMO Global Alliance in India. In today's engaging panel discussion, a focus will illuminate the recently enacted Digital Personal Data Protection Act and its far reaching implications on startups, projects, and the very fabric of PMOs. We are privileged to have experts in cyber law, data security, cybersecurity, as well as accomplished startup founders on board who will provide us with profound insights into this matter. It's essential to take a moment to express our gratitude to our event and knowledge partners, Pavan Duggal Associates, Delhi Startups Club, and India Blockchain Forum. Their contributions have been pivotal in bringing this event to fruition. So, without any further ado, let's dive into the heart of our discussions as I hand over the reins to CS Rajiv Bajaj. Rajiv, over to you.
Thank you, Priyanka, and uh, uh, thanks to the Pamoga Hub for organizing this event. I'm Rajiv Bajaj. I represent Delhi Startup Club, and I have my own consulting company called Bajaj and Bajaj Corporate Chambers. So I'll be taking you through the interesting panel discussion. We have with us Mr. Pavan Duggal, Dr. Pavan Duggal, who is advocate from Supreme Court of India. We also have Colonel Dr. Inderjeet Singh, Chief Cyber Officer, Vara, and Mr. Prasad Deore, Senior Director, Data Security Council of India. So, friends, as you know, the DPDP Act is having far-reaching implications. So, today in our discussion, we'll try to understand what are those far-reaching implications, particularly what is the impact on Indian startup ecosystem, because I think these days we are all trying to focus on the startup ecosystem, and the Prime Minister himself is very gung-ho about the progress India is making. Let me take you through the background of DPDP Act. It was in July 2017 when MeitY constituted the expert committee under the chairmanship of Justice B.N. Sri Krishna. And from there, in August 2017, because of this Aadhaar case where the Indian government recognizes the right of privacy as a fundamental right. That's where the Justice Sri Krishna Committee was constituted. And from that, if you look at, MeitY released the report and the draft bill. It was named as, it was referred to JPC, and it was named as the Personal Data Protection Bill at that time. But then we moved on, and Indian government withdrew the draft PDP bill and reintroduced DPDP bill in 2022, in November 22. And and in August, we have seen the bill being passed. So there have been challenges. So we will, take you through all those challenges. So my first question is to the entire panel. So first, Dr. Duggal. So with the enactment of this act, sir, what sort of impact do we see for emerging Indian tech startup industry, and what kind of around on the processing and storage of data?
Thank you, Mr. Bajaj, for your opening comments and for the question. To begin with, let's understand one fundamental ground reality, and that is the entire tech ecosystem in India is going to be covered, and it's already covered under the DPDP Act 2023. This has received the assent of the President and has become the law of the land, though Section 1 of the said Act says that different sections of this or different provisions of this particular law would be implemented from time to time as per the directions given by the central government. So do expect a phased kind of implementation of this law, but everybody in the tech ecosystem that's dealing with personal data of others, whether it's personal data of employees, customers, business partners, associates, clients, would be now totally getting covered under this new law. And I think we'll have to understand one fundamental ground reality, which is that if you are now not going to ensure compliance with the foundational fulcrums of this newly emerging law, which is both consent as also notice, you are going to be playing with fire. For example, the law mandates you that if you are an Indian tech community stakeholder, you will have to give notice to all your data principals, telling them that you would be collecting this kind of personal data for these specified purposes. Notice will have to be crystal clearly given in writing, and that notice will also specify the specific purpose for which the particular data collection has to take place or processing has to take place. Once the notice is given, the onus will be back upon the data principal that he or she has to give you an unqualified consent to the said notice, thereby giving consent to the processing of his or her personal data for the specified purposes. Only once you get consent can you actually go ahead and process data. If you are not doing these fundamental steps, you are automatically in violation of this law. And these two violations are very, very strong. They're enough to earn you fine up to 250 crore rupees per contravention. Now, this kind of a fine is unheard of in the history of independent India. 250 crore rupees per contravention, and that money does not go to a complainant, that money goes to the consolidated fund of India. So clearly, this is such a big amount that any startup ecosystem player or any Indian tech ecosystem player is bound to be prejudicially impacted in case if such a fine is going to be imposed. So the focus will increasingly have to be on ensuring compliance. This law is now spelling the death nail of the Indian Jugaad School of Management in the Indian data ecosystem. No longer will you be as tech startup ecosystem players be able to do Jugaad, because once you do Jugaad, you will be forging electronic records. That becomes a specific heinous offense punishable with 7 years imprisonment and fine under section 468 of the Indian Penal Code. So proactive compliance will have to be your only mantra. The time has come when you'll have to realize that the DPDP Act will have to be taken as a consolidated, complete code in its own self. And various subsections of the said law are going to be taken as subcodes. And the only option available to the all data economy stakeholders, including the startup economy stakeholders, would be to ensure proactive compliance. You don't comply, and you suddenly come into this very gray zone where you could be earning a fine up to 250 crore rupees. In addition, there'll be now requirement for you to go ahead and mandatorily report personal data breach to the Data Protection Board of India. You don't comply with this, you get another 250 crore rupees fine. And also, you have to realize that once that happens, you automatically lose your statutory exemption from legal liability under Rule 7 of the IT Rules 2021, thereby making you liable for being punished for various offences under the Indian Penal Code and the IT Act. So, all said and done, it's a game changing legislation. New rules and regulations are awaited. The government is in the process of examining those rules and coming up with those rules. So, let's quickly realize and wait what kind of rules are going to come forward. But since the rules will only be fulfilling the major objectives of this legislation, it will be in the interest, business interest, and legal interests of every organization in the country who's dealing with personal data to start getting their preparations for the basic elements in the foundation building blocks which are given under the various sections of the DPDP Act 2023.
Great. Thank you so much for very insightful comments, Dr. Duggal. And you rightly said that it's going to be a game changer for everyone. So, Colonel Inderjeet, what's your initial comment on the Act?
Yep. Thank you very much, and it's really a pleasure to be part of a wonderful discussion today. And in fact, the DPDP Act has instigated a very transformative journey for the Indian tech and startup industry, and that's what we are seeing. And that everybody was waiting for this as to how it's going to change, uh, demanding adaptation. We are looking in for innovation. We are looking for renewed commitment to the data privacy, because everybody has been talking about the data privacy, but how are we going to change after the DPDP Act is comes as a law, and we do it. While the challenges, it's going to persist. It's not going to do away with that. Everything is going the way the way it is today. It's going to change totally radically, but the challenges would be there. But the act is, going to have a very positive influence on the data protection, and the user trust is undeniable. And the other important thing is that we'll have to have a very privacy-centric solutions in due course of time as a tech startups which are concerned. They need to will have to have a better quality of encryptions we never thought of, data at rest, data at motion, your differential privacy we have to be talking of. We have to be talking of something of anonymization techniques to protect the user data. And while we still extract the valuable insights from the data, right? So those are the kind of innovative things which we'll have to think of. We'll have to innovate that. And something the tech startups is going to have a kind of a new fuel. There'll be data auditing, there'll be privacy consulting, there'll be consent management platforms which will come up. It's really going to create a new avenue for the startups to thrive altogether. So if you look at it, it's going to change the whole ambit of the startups and new avenues which are going to change the way we are doing a lot of things. So whether it's a global collaboration, your other kind of regulatory adherences, so lots of things which are on the anvil right now.
Thanks for sharing the opportunities for the startups. Mr. Prasad, what is your initial comment on the Act?
So I think it is a landmark legislation, especially after deliberation of 6 years. And we went through many iterations. It was probably initially 150-page document. Now it is 21, 25 pages document, pretty concise. And if you look at the act, the word digital underlines the importance of how India is going to move in this decade. And I think it is also offering, if you look at tech industry perspective, a level playing field for startups as well as tech giants. Today I think someone needs to go on mute. There's a lot of disturbance. Uh, it also so it is helping, in fact, all of us to have trust in the startups when they're asking our consent, because we know that they are governed by framework now. And the act itself is a framework based, as it is technology agnostic. And as Pavanji said, we will wait for the phased implementation and recommendations and guidelines from the government on this act. So overall, very positive. I think immediate impact would be on industries which are dealing with personal data. It could be BFSI, it would be online platforms, e-commerce platforms, healthcare industry, and obviously public sector enterprises which are dealing with personal data. And they need to make sure that they have a technology framework to address all the provisions of the principles mentioned in the act. It, like, taking consent, protecting the data, rich management. So all for this, all the technology framework has to be ready. In fact, they'll have to ensure that they have a data privacy office or a data privacy program. In some cases, they might have to hire a data privacy officer. So these are immediate implications from industry perspective.
Uh, Thank you, Mr. Prasad, for that insightful comment. Colonel, we normally, see that small enterprises and startups, they don't have enough bandwidth to invest in major amount of in data security and protection. So, do you think there'll be some change in the way startups operate because of this act?
Yes, and it's very important you have to understand that there's going to be a fundamental change, and the regulatory framework, it's kind of bringing a paradigm shift where the way the startups handle the data, they process the data, they protect the user data, and right now for any AI for that matter, if you look at it, the data is the most important factor, right? So while having said so, they have to look in how the startup operations are being impacted with the non-availability of data, with the consent data which is there. So they have to have, like I spoke of, a privacy-centric approach. They now need to look in for a data-centric approach, and uh, and that is where they have to really think in that how the data privacy and protections are no longer secondary considerations, but the integral component of their business strategies itself. And we never thought of this particular aspect, right? So that will change radically the way the startups are being brought up, because that's where the startups are not very cash rich to invest in these kind of things. They don't even think of, because they think the data is free and they can use the data they wanted. Now, the startups really will have to kind of prioritize the collection, storage, processing, compliance with the X principle. And like Dr. Pavan Duggal brought up, though initially the startups are out of the ambit of a lot of things to begin with, till the time they settle down. I think that's what the law will come in. But then also there's going to be a lot of kind of impetus on the fines if they are not following the law of the land, and they will have to kind of go in for a enhanced user consent, and they will also be requiring to have the permission to collect and utilize the data, which is missing now. So that means they'll have to have to go through some consent managers, and also the data principles where they're taking the data from, and it will kind of the consent management will be a bigger thing altogether to handle and have all the data principles informed of the data what they've collected. So that is the most important thing. Other thing which are important is the data handling practices. We right now, whenever we give data to anyone, we are really not bothered and what and how they are using it. But the startups will have to overall the manage the data handling practices to align with the act's requirement, and involve implementing stringent security measures, regular audits, risk assessments to ensure safety and privacy of the user data. So those are the kind of things which the newer DPDP Act is going to bring for the startups.
Yeah, thanks, Colonel. We have seen, Dr. Duggal, many data incidents of data breaches. Air India breach, there was a CAT data breach. We have had Uptex data leak, which was quite a huge so it was debated that in the absence of artificial intelligence and these tools, uh, what kind of impact it's going to have on the AI, because you are an expert in this area. Because of the AI, do you think any uh, coverage of DPDP Act is going to be impacted?
Well, clearly with the AI coming in, DPDP Act will have a direct bearing upon the AI. Because one, and I'm using either a generative AI tool or a normal AI tool, if my activities will land up to collection of personal information, I, even as the licensor or as a licensee, will have to further go ahead and ensure that I get the appropriate consent of the data principals after giving notice. Merely because I'm using AI does not mean I'm going to be exempted from the applicability of this law. Why? Because this law is saying that it's going to be applicable to every personal information in the digital form, or even personal information which is not in the digital form originally, but which is subsequently digitized. So people should have no kind of a misconceptions that because they will use AI, if the AI collects personal data, then they will be exempt from this particular law. That's not the position. Yes, it's correct that India today does not have any dedicated law as far as artificial intelligence is concerned. It's also correct that the Information Technology Act 2000 is also silent on issues pertaining to AI. But ultimately, this particular DPDP Act is dealing with personal data in the digital format or personal data in the real world format, which is then subsequently digitized. If that's the position, then clearly every stakeholder, whether you are using AI or not, will have to ensure compliance with the applicable provisions of law. This will have to be the only mantra, but that does not mean that you will give the compliances under the Indian IT Act and rules and regulations a miss or a go by. Let's be all very clear that the DPDP Act is not a special legislation. It's a legislation in addition to the existing law, which is the Information Technology Act 2000. Obviously, the way the law has been drafted, there's a lot of potential conflict that's going to arise between the DPDP Act 2023 and the Information Technology Act 2000. The reason for this is that the Information Technology Act 2000 is India's mother legislation for everything electronic. So in India, if you are using computers, computer systems, computer networks, computer resources, communication devices, as also data and information in the electronic form, you are going to be governed by the IT Act. Yes, it's only when you're dealing with personal data that you would be governed under the DPDP Act. Though when I look at the definition of the term data, both under the IT Act and the DPDP Act, it's very clear that both the definitions are not the same, and there are intrinsic conflicts in the said definition. So as we go forward, one of the key important priorities of the government should be how can these potential discrepancies and inconsistencies between the IT Act and the DPDP Act can be potentially harmonized in the best extent possible so that the personal data of individuals or users in India get potentially protected by means of the various detailed parameters that are given under this particular new legislation.
Right, you are right, sir. Because of this lacunae, I think some inputs from you need to go to the government for correcting this position, because this may be a situation down the line. I come to Colonel for our next question. Colonel, in the fintech industry, and the startups and payment aggregators have lots of challenges. And do you think this DPDP Act is going to impact them further?
Greatly, I'll say. And it's really going to create a additional compliance burden on the fintech startups. I'll not say burden, but it's a compliance requirements they will put it, and especially the payment aggregators who are operating in India. Because, like I brought it out, uh, it involves collection of data, processing, financial details, your PIIs, which are the storage of sensitive financial data. Uh, when it comes as a law, it will be required to comply to all those, and they will also have to have the data protection officer. They need to appoint that, conducting privacy impact assessments at a regular basis, and they will have to kind of contribute towards the increased operational cost of the fintech startups, because it's going to cost overheads altogether, and the payment aggregators to put it across. And for the smaller players who are coming up as fintech startups, it will impact them on the cost, because whatever you say, uh, there's a cash crunch when it comes to for the fintech startups to roll out a business. And when we have the whole kind of ecosystem and the regulation which we have to follow, uh, where we are going in for a stringent data handling standards with DPDP Act. So it will cost a lot. And also the user consent challenges which are there, because right now those challenges don't exist, but obtaining explicit information, and you have to have the information given to the user, taking their consent is going to become a critical aspect of the act. And the fintech startups taking a and securing consent for the financial data processing might pose a unique challenge, right, due to the technical complexities of transactions and need to provide a clear explanation to the user. So that's another kind of thing. And we've been talking about the data localization that will also kick in, because most of the fintechs do work internationally also. They will also have challenges of cross-border data transfers, which are going to happen. So net compliance cost is going to increase, and it's really going to bring in the whole look to the way the startup, or especially the fintech startups, are going to get into the business, right? So that's the kind of thing which is going to happen.
Yeah, Mr. Prasad, your comments on the fintech startups. What's the impact? Yeah.
See, I'm actually, as such, I'm happy for fintech ecosystem. Uh, One of the reasons is that our fintech is now reaching out to globally. If you look at UPI being adopted, or we're trying to use UPI in Germany, and yeah, recently UAE as well, we've seen that government announced that UPI would be one of the modes of transaction. So when you go abroad, I think you need to demonstrate your accountability, and such regulations help them demonstrate that accountability and establish the trust with your consumers. So in a way, that is a way to look at positively. Even the investor community which invests in fintech now, they will also have better confidence. While there will be certainly a cost for implementing these measures, but they'll also be able to attract better investments because there are regulatory framework which is guiding them. uh, Third is, there are certain provisions around exemptions for startups. I think we'll wait to hear what kind of rules will be applicable for startups. And I think they're being a bit liberal about startups. That's what I feel. This is the initial inputs which we have received.
Okay. Dr. Duggal, I come back to you. If we look at the new act, it lays down the clear accountability on data fiduciary for data processing and protection. So, what's your comment on this? How do you look at it?
Well, I think that this legislation is a landmark legislation because for the last more than 23 years, ever since the IT Act had come across, we did not have any legal framework which could provide for any accountability of any data stakeholders. So, right now, when I look at the particular DPDP Act, there are three broad stakeholder players on the center stage. Number one is the data principal, to whom the data belongs to. He is the owner of all such data, including personal data. The next concept is that of data fiduciary, who will determine the way how the personal data of the data principal is going to be processed. And the third category is the data processor, which will process the data of the data principal on behalf of the data fiduciary. So, in all these three stakeholder interplays, I think the role of data fiduciary becomes of crucial importance because he determines the manner how the data, personal data of the data principal is going to be going ahead and processed. Now, therefore, the biggest liabilities that are going to come on data fiduciaries. Ultimately, some liability is also going to come for data processors, but they can always take the ground that, sir, I'm only an agent of the principal. The principal here is the data fiduciary because it's the data fiduciary who's determining how I have to process the data. And in case if the data fiduciary has not complied with this particular law, then you please catch hold of the neck of the data fiduciary, straddle him with 250 crore rupees fine. So at the end of the day, data fiduciaries will have only one option, which is that to focus and rededicate themselves towards more transparency, more accountability, having have in place appropriate transparent mechanisms for obtaining of consent, giving appropriate notices, and also complying with the various other parameters of the DPDP Act. And if they don't comply with this, then this 250 crore rupees fine, Damocles sword, is going to hang on their particular head. Therefore, I think every company is going to take the entire DPDP Act far more seriously. Now, there's one particular question area, sorry, and that is that when would this DPDP Act be applicable? So the DPDP Act has already become the law of the land, but it's not been implemented because Section 1 says that the central government may go ahead and implement different provisions of the law at different points of time. So all said and done, intermediaries, including data fiduciaries, will have to play a very important role in this regard.
Thank you, Dr. Duggal. Uh, Colonel, your comment on this particular
I
aspect.
resonate the same point as Dr. Duggal, and it data processing. Yeah, yeah. I'm audible.
Okay. Yeah, you are. Yeah. There was a lag in between, but yes.
Yeah. So I was just saying, I resonate the same points as Dr. Duggal, and uh, the DPDP Act, it establishes a framework that lays very clear accountability for data fiduciaries for data processing and protection. And data fiduciaries are required to exercise a duty of care when handling the personal data. And they would have to really ensure that the data is processed in a manner that's fair, reasonable, and not causing the harm to the data subjects. And the transparency is the other aspect, uh, which is kind of undeniable, uh, very much important. And data fiduciaries are obligated to inform data subjects, principles about the purpose of data collection, the nature of data being collected, and intended recipient of the data, and of course the user consent. They must obtain explicit and informed consent from the data principals or the people before collecting and processing the data. So, having said so, one thing which is another very interesting thing is the data minimization, and this act brings in the data fiduciaries to, in fact, collect only the necessary data which is relevant to be used or intended purpose. So any unnecessary or excessive data collection is discouraged as part of the act.
Right, right. Thank you very much for your insights on this. Mr. Prasad, this is a very important aspect. So, your comments on this. You are on mute. You are on mute.
The act is pretty balanced, and we will wait to hear on the rules and for the notifications. But as such, act is pretty balanced. While it is putting certain obligations and duties, it is not to the extent that it would curb the innovation, and especially from startup perspective. So pretty balanced act, and also it is imposing obligations on data principle. So we'll wait to hear for further rules on certain aspects, but I think as of now it looks like pretty balanced, and even the data fiduciaries should be happy. Looking at it's not that cumbersome compared to some of the
Yep.
other regulations in other geographies.
Right, right. So lots of questions coming in, but we'll come back to all the questions. Let's finish with our initial discussion. So a lot of action, a lot of exemptions are also there. Data Protection Board of India is going to be a reality. So are there any specific nuances which tech and startup industry need to know in terms of compliance under this act, Colonel?
So the tech startups should be aware of the consent mechanism which is there, data minimization, especially when we have the AI startups, the startups which are there, which primarily leverage on the data to drive insights from larger data sets, right? And uh, here the data, in fact, the data minimization we are talking of in the act, and it promotes data minimization. That means the only the valuable amount of data needs to be collected. So the startups will have to carefully evaluate the data they collect and the purpose what they collect it for, avoiding the over collection that might violate the principles. But then, when you look in from a technology standpoint, and talking of AI, you require enormous amount of data to reach to the accuracy part. You have to have the privacy impact assessment, which needs to be done as part of the compliance when you're developing a new tech solutions, and you need to conduct privacy impacts to identify the potential risks for the user privacy. And this is very important for solutions that process sensitive data or for the novel technologies which are there. So the then other things are like in the data is mishandled. How do you really have an incident response plan? So that, I think, as we really unfold the whole uh, kind of act, there are a lot of things which will fall out as to the companies will have to have the incident response plan to handle data breaches effectively, because that is also going to be a kind of a problem which is going to come up, and they will have to have a clear process in place and notify the affected individuals, right? Privacy policies will have to be incorporated, and privacy by design would have to be thought of. And other thing which comes to my mind is the third party data processors which are going to be there, because everything is not going to be organic data. Something would be a third party data service providers to process the data on their behalf, and they must ensure that the processors really kind of adhere to the act guidelines. They are within the framework of the act, and they also handle the data protection responsibly. So those are the kind of things, initial thoughts are on coming to my mind.
Okay, okay.
I would like to add
That's
to a few
insightful.
things,
Yeah, yeah. Please, please, please.
Rajiv. So I think, well, he has captured really well, Colonel. Fantastic. I think certain things industry needs to think about is, build your privacy structure within organization, privacy organization structure. You to identify what kind of skill, competency, position you need to also seek consents of individual whose data you've been processing. You're likely to face issues like, do you have a record of consent obtained in past? Do you have coordinates of those people now with you? And these are certain things you can do before the act commences. You have to make sure that look at your privacy policies. I see a lot of organizations have privacy policies which are obtaining bundled consent. You'll have to have itemized consent. It is clearly stated in the law. You to have your notice in different multiple languages. So certain these things can be addressed before the law commences. You have your lead time. Obviously, industry should need to come together and identify the consent manager mechanisms, which is account aggregator, or they will have their own consent manager, how that mechanism will be placed. You to register with the board. So those mechanisms need to be explored. When you go to data principals who have given consent in past and you have to seek their consent again, the data principal will be bombarded with the requests, and how you're going to handle that. It's interesting again. So validate or build contracts with the third party processors. So it could be your vendors, partners, affiliates. Most of the contracts today may not have these clauses of the safety and security and the contractual obligation with these third parties. Now you have to look at your contracts, and especially from e-commerce perspective, it will be humongous task. All your partners also need to make sure they are onboarded. um, so these are the immediate actions I think we need to look into.
Right, right. You're right. So I come back to Dr. Duggal on a broader perspective, sir. What do you think? This is going to have an impact on the digital initiatives and digital economy of the country. This act.
Well, the DPDP Act is effectively going to propel the Indian digital data economy onto a new zone of progress, growth, and development. One of the primary inhibiting factors of the growth of this data economy was the fact that there was lack of any enabling legal framework in the country which could go ahead and regulate the processing of personal data. Now that this particular law has come into being, and now that very exemplary fines of 250 crore rupees have been stipulated under this law, suddenly I would expect a new trend where more and more stakeholders would be inclined to err on the side of caution and would ensure proactive compliance with the provisions of this law. Needless to say, the Government of India needs to give adequate time to the data economy stakeholders so that they can have appropriate time to transmigrate and needed to go ahead and ensure complete the provisions of the law. When I look at the General Data Protection Regulation, legal frameworks in the European Union, there also sufficient time was given to the concerned data stakeholders in order to ensure compliance. I expect something similar to happen in the Indian context. However, that does not mean that if you're going to comply only with the DPDP Act, you are absolutely fine and ready to go. Sorry. You will have to realize that this particular law is in addition to the other prevailing law, which is the Information Technology Act 2000. And you will also have to be ensuring compliances with the IT Act and rules and regulations, specifically the IT Rules 2021, which have been updated on 6th of April 2023, and also the IT Directions 2022. Why? Because the DPDP Act is only providing for a civil liability of 250 crore rupees fine, whereas the criminal liability is going to run in conjunction with the civil liability of 250 crores in the form of the criminal liability which is given under the IT Directions 2022 when you do not mandatorily report any of these distinctive cyber security breaches or cyber incidents to the Indian Nodal Agency on Cyber Security, being the Computer Emergency Response Team of India, all within 6 hours of coming to know about the said cyber incident or cyber security breach. If you do not fulfill that 6 hour golden time frame of 360 minutes, then you automatically commit offense punishable with imprisonment and fine under Section 70B of the IT Act, and that's going to expose you and your company to legal criminal liability. Why? Because the company cannot be sent to jail. Therefore, the top management will have to be sent to jail. So every person who occupies a responsible official position pertaining to the operation of the device or management of its activities or the day-to-day operations on the business of the company shall also be deemed to be guilty of the said offence thanks to Section 85 of the Information Technology Act 2000. Hence, I expect various layers of compliances. One, compliances for organization. Number two, compliances for protecting the top management of the organizations from exposure to criminal liability. And number three, specific proactive compliances under the DPDP Act. And on top of it, if your company is an intermediary, which 99.9% of the Indian ecosystem data stakeholders are, then in addition, you will also have to ensure appropriate compliances as an intermediary and also document the exercise of due diligence while you discharge your obligations under the law. Needless to say, the various compliances for cyber security, which are given under the IT Act, and also the information technology, reasonable security practices and procedures, and sensitive personal data or information rules 2011, as also the IT rules 2021, will have to be in addition complied with in conjunction, in parallel by all stakeholders. So I think the times are now gone where you can say, I will just manage. I'll cross the bridge when it comes. Sorry, sir, you will now not be able to do so. And if you try to do so, maybe you are lucky, maybe you are not. We Indians love the game of cricket, but if you are not going to comply with this law, this will be something like an ask where you will be asked to hit 6 sixes in the last 6 balls of a T20 match. I'm sure people realize that is one big task that most of the Indian companies may not land up achieving. Therefore, proactive compliance with the DPDP Act, adopting it as a distinctive, complete code in its own self, and adopting DPDP Act and its provisions as way of life for organizations, for data stakeholders, will be the next proactive step so as to protect themselves from exposure to both civil and criminal liability in the coming times.
That's very well elaborated, Dr. Duggal. Ms. Prasad, I have a quick question for you. What are the rights and duties of data principals, in this act? You are on mute. You are on mute. You are on mute. Yeah.
So,
Now, sir.
So, like any other data protection law, I think right to access your information about personal data, right to correct or erase your personal data, right of grievance redressal, right, and there is also new provision right to nominate for person with disability or for in case the data principal is not incapacitated. So these are the provisions or rights. And interesting thing is, in our context, they have also identified duties of data principal, and which is very important and very unique in this case, where you're not supposed to suppress any material information that you're providing, with your documents, your identifiers, or proof of identity, um, or any to state or any of its instrumentalities, and you also should not register any false or frivolous grievance or complaint with data fiduciary or the board. You should not impersonate another person while providing their personal data. for any purpose you're sharing that information. So these are some of the very important rights and duties for data principal, and I think this is one of the unique provisions which not there in many of the other regulations.
Right. Thank you so much. We have a few interesting questions coming in. So we move to our question and answer session. Dr. N.K. Dhupar, he has sent a question. Would the compliance of the Act not affect the cost of the startups? I think we kind of answered it, but uh, Colonel, you can quickly comment on
Yes,
it.
yes, thanks. It's an interesting question. And while we are fueling the startup and we are a kind of a startup nation altogether, with so many startups happening, it's really going to have a cost impact. Uh, and definitely, I was trying to tell you the concerns, the data privacy officer, uh, your data privacy driven strategies, everything is a cost. So nothing comes free of charge right now. But this is a great act when it comes to coming into force. But at the same time, you have to understand in this act, startups have been given a lot of leeway in the initial part of it. As it comes as a rule, the clarity will come up. But initially, startups are kind of going to, have the way they are wanting to use the data.
Okay, thank you. We have a question from Prashant. He says that uh, right now each and every startup focus on a business and compliance centric approach, but after DPDP Act, it is expected that the approach will be changed to user centric approach. So, what's your comment on this, Mr. Prasad?
I think yes, these kind of provisions are actually user centric, and if you look at the way it has been termed data principle, it shows our way of thinking. Even the word data fiduciary, what it is implies is actually trust. So yes, it will move certainly to user centric approach. It is good for businesses, not to make compliance as a check in the box activity, but look at it from user perspective. There are various models already established how you think, how you approach from user perspective. And as I said, right, anyway, user centric approach helps the startups or the ecosystem because it builds trust.
Okay. Uh, Dr. Duggal, there's an interesting question which by Suman Ghosh. It says, how does the DPDP Act has relevance on RTI Act 2005 itself? Are these acts have dependency in between them and they are independent of each other? And is there any likelihood that RTI Act
So clearly,
may
these two
also get revised?
legislations are going to
Yeah,
be connected to each other.
yeah. Dr. Duggal? I think he has connectivity issue. Can you, Kanal, comment on this?
Yeah. So it's a kind of just if you can repeat the question.
How this DPDP Act is going to have relevance on RTI Act? Uh,
Okay, so it's like this in the RTI Act, Section 42. There are certain personal information. Whenever you ask for a RTI Act and uh, you ask for pay scale, your age, your qualifications, and all those kind of inputs which you're asking, and those were as part of the RTI. One could have taken it after applying for the RTI. With the DPDP Act coming in, those come under your data privacy act. You cannot have that information on the fly, right? Your
yeah.
pension, your pay scale, your kind of the salaries which you're drawing. So those kind of changes which will have to be done in the RTI act retrospectively when the DPDP act comes as a law.
I agree with
Okay.
Colonel. In fact, yeah, there will be cases where it might conflict, and there will be to be discussed and deliberated. In fact, RTI officers will have to be take more precautions when they are sharing information which is of personal nature.
So the data is not going to be on the platter anymore.
Yeah.
So the data is not going to be on platter anymore to anyone. It will be kind of filtered out and given to, and that's why the RTI Act would also get amended.
Yeah, that's what we all feel. Okay, there is another question from Arnav Barman. He says, does the review as a process extend to vendors? Will that be a requirement? Mr. Prasad?
Can you repeat the question? I'm not. So it's on the
It,
screen.
it, it says, does the review as a process extend to the vendors? Will that be a requirement?
So review in the sense, if you're looking at entire process life cycle of data life cycle, and if you're sharing your data with the processors, you need to have a contract mechanism with those data processors. And if they're your vendors, partners, affiliates, as I said earlier, yeah, they will be under purview, and you as a data fiduciary will have to safeguard your interest as well.
So primarily, I'd like to add here,
Yeah.
everyone in the whole chain is going to be responsible, right? So it's not going to be that one can shy away from their part of the responsibility and say, uh, you know, I'm not responsible. So data processor, data principal, consent manager, your data fiduciary. So everyone is going to play their role properly.
Thank you. Uh, Welcome back, Doctor. So we lost you in between. So your comment on this RTI thing, sir?
I think both these laws are intrinsically connected with each other, and therefore there's going to be impact to the DPDP Act on the RTI Act. Therefore, as we go forward and as we see more rules and regulations coming in under the DPDP Act, maybe there'll be a need for going in and revisiting the RTI Act in that particular regard. This becomes even more essential as the government and its various agencies have been given the power to be exempted from the applicability of the DPDP Act. It's a very interesting area that we'll have to wait and watch.
Yeah. Thank you. So there's another interesting question from Priyanka. She says, what potential challenges or pitfalls should product managers anticipate when navigating the intersection of tech product development, user data, and legal compliances? So
Is that a question to whom?
yeah, you can address
So
it,
I
sir.
think okay. Sorry.
Yeah.
So I think there's something called privacy enhancing technologies. You need to make sure that the product architects understand these privacy enhancing technologies, how first you collect only minimum required data, and then look at the data lifecycle in your product, and where all data resides, data in transit, data at rest, in use, and what are different controls can be deployed on and those various digital assets which are managing your data life cycle. So it could be anonymization, it could be pseudonymization, encryption. In some cases, if it is very sensitive data, you may go for a zero knowledge proof like of concepts or technologies or techniques rather. So yeah, they will have to be privacy aware, and even your development team, they need to understand what DevSecOps is, how they can secure their code, what kind of coding practices they have. So whole lot of transformation or awareness has to happen in the product development team, product architects, and uh, you might have to have the privacy enhancing tools that you need to deploy on your for your operations, product management operations.
Okay. Interesting. So we have another question from Suman Ghosh. She said, how can the incorporation of AI within the DPDP Act enhance the effectiveness and relevance for startups? Or what role can artificial intelligence play in streamlining DPDP Act adherence for startups? And what potential benefits might this offer? So, Dr. Duggal, you already handled this question, so you can throw some light on this. Yeah.
See, clearly now with the generative artificial intelligence becoming the flavor of the times, everybody now wants to find out how can I use AI, specifically generative AI, for the purposes of ensuring compliance with the DPDP Act. Now, you'll have to quickly realize that this looks a very exciting and a sexy proposition, but in given the fact that the legal frameworks on AI are not well crystallized, I would really advise caution and care for organizations when they are treading this path. Why? Because even the coders of artificial intelligence have no clue of how the cognitive intelligence of machines is evolving with the passage of time. So, till such time India comes out with legal frameworks, it will be good for the startup organizations to start being more conservative. But if they are using AI, and if as a result of the use of AI, somebody's personal information gets compromised, misused, abused, or unauthorizedly accessed or disseminated, then that particular company or startup that's using this AI product is going to be exposed to a fine of 250 crore rupees. So the question right now is, will a startup company want to put its neck in the hands of a box AI who we don't exactly know how it behaves. We don't exactly know what kind of personal data does the said AI collect without or with telling us, and where is it all going to be disseminated? Because if you're going to be using AI for ensuring compliance with the DPDP Act, then AI is going to become my data processor. Because I, as a company, I, as a startup, will be a data fiduciary. Once I am a data fiduciary, I am going to be in any case responsible for all the acts done by the AI in its capacity as a data processor. Now, till now, I have physical world processors. I know them. I reach out to them. I have an knowledge of their processes, and therefore I can be reasonably sure of the practices that they follow. But in the case of AI, I am virtually dealing with a black box. I don't know how the AI functions. I don't know what coders have written into the said AI, and I also don't know what kind of legal harm may befall upon the data principals once their data is going to be processed, dealt, or handled with by artificial intelligence, including generative artificial intelligence, as data processors. So I think right now it's too risky a game to start working in that direction. Yes, once there's more legal clarity on the legal parameters and frameworks for AI, then in that regard, I think I'm very clear that the decks can be more opened up for more constructive use of AI in the context of DPDP Act.
So I would like to
Thank you.
take the second part of the question,
Yeah.
Raji, if you may.
Yeah.
What how AI can be used in for DPDP bill act rather is we can throw our privacy policy notices to LLMs and see where are the nuances which we are missing actually. Second aspect is also look at the customer's perspective. 2016 there was a survey done in US, and the number of digital services we are consuming now, and if you look at number of data controllers, and then there are third parties, and sometimes it is written in the privacy policy for so and so we are sharing your data, and if you want to review their data policy, please click here. So or it could take 50 odd days if the kind of services we are consuming to just read the policies. What is the tool in the
Right.
hands of consumer today? And if we have a risk indicator which works on AI, which crawls the websites or privacy policies of the app or website you're accessing and gives a risk indicator, that would be a big value add.
Thank you. Thank you very much. We are approaching the clock is ticking to 7 o'clock. But last question, Colonel, for you. We have a question from Mr. Om Prakash Singh. He says, as there would be a requirement to report to the board in case of any data breach, please share your thoughts on present guidelines to report CERT India within 6 hours.
So primarily, if you have to really report, any cyber attack which happens within 6 hours to CERT India,
Yeah.
so they ask for your logs, and
Yeah.
most of the companies really, falter in giving the logs because you may be having, some antivirus or anti-malware or your SIM, but there's don't generate the log in the manner which is required by the cert. So primarily, what you need to do is you need to have solutions like SOAR, which are more required with the way they generate the whole lot of logs, which what happened in your network, and you report to CERT India in time. Having said so, what you need to do is you need to also have a threat intelligence or attack surface management of your network. And where we are faltering today is everybody's looking the security inward out. Everybody thinks all my networks are secure and the threats are outside. It's a time when you really need to look at the security outward in and continuously monitor your network from outside as a attack surface management and see what's happening in your network. And if there is a violation or there's a vulnerability, there's an APT attack or there's a malware or a ransomware which is hitting your network, you get it on the fly. Gone are the days when you did a VAPT or an audit 6 months and then you kept tight on that report saying, hey, I'm fantastic, I'm safeguarded, right? Because the moment you do a VAPT, don't be surprised, you may have an attack which you will not come to know for the next 1 year. So that's the way we have to look at the whole thing.
Thank you so much, and thanks everyone, Dr. Duggal, Mr. Prasad, Colonel, for your very insightful comments and sharing of your vast knowledge base. So I think we are conscious of the time, so I hand it back to you, Siri, for concluding remarks. Yeah.
Thank you so much, Rajuji. Good evening, everyone. Again, on behalf of PMO GA India Community Hub, I'm Sri Sudarshan, the Director of Communications. Would like to thank you all for taking out your time on a Saturday evening in attending this panel discussion on DPDP Act 2023 and its impact not only on Indian startup ecosystem as such as the IT sector or across all the sectors which is in India. You are participating today, which means that this shows your interest towards this topic and the event, which motivates PMOGA India Hub to organize more such PMO Insights events. Of course, as you see, there are a lot of questions flowing up, very interesting questions, such amazing answers regarding the Act, how we are supposed to respond to CRT, all those things, impacts of AI, how AI can be used. All those are some amazing, insightful discussions from all our panel members. I thank everyone, the panelists, Dr. Pavan Duggal, Colonel Dr. Inderjeet Singh, Prasad, Deore. They really shared their expertise and insights with us. Of course, your questions from the participants really made it a wonderful discussion. We are also grateful to all the esteemed panelists for their time, for the willingness, and sharing their knowledge with us. CS Rajiv Bajajji, thank you so much for leading this discussion. In a way, it was very informative and most engaging to all of us. I would like to take a moment to thank our knowledge partners, event and knowledge partners, Pavan Duggal Associates, Delhi Startup Club, and India Blockchain Forum for their wonderful support in making this event possible. Last, I would like to take this opportunity to communicate to all that PMOGA India Hub is back with our flagship PMO India Awards 2023 event this year. So just to give a background, the PMO India Awards acknowledge and celebrate achievements and accomplishments of PMOs and PMO leaders within India. So there are two award categories. One is PMO Leader of the Year that recognize the most prominent PMO leader in India in 2023. And the other one is PMO of the Year that recognizes the best performing PMO more at a corporate level in India in 2023. So the nomination, so step up, step forward and shine bright. Nominate yourself for the PMO India Awards. You can log on to our website, pmoga.world/PMO India Awards. And we would like to meet you all in the awards event soon. Please, have a look at our LinkedIn community as well. There would be a lot of posts and inciting informations coming across. And finally, we hope that you found the discussion informative and useful. We look forward to see you at the next event. Thank you, everyone, again for your time and participation.
Thank you. Thank you. Thanks a lot.
Thank you, everyone. Thank you so much.
Thank you. Thank you all.
Thank you.
Bye-bye.
Thank you. Bye-bye.